Good morning. Welcome to today's session of the 5th District Court of Appeal. I'm Jamie Grosshands, joined today by Dan Traver and John Harris. We will be hearing the case, let me get the exact title, Coast Development Corporation versus Old Republic National Title Insurance Company, case 19-1791. Can both attorneys see the clock?
Yes.
I will reserve 5 minutes for rebuttal for the appellant. Mr. Gonzalez, if you would like any additional time, they will adjust the clock accordingly. And then Ms. Hatchett, if you would mind muting yourself while Mr. Gonzalez is speaking, and then Mr. Gonzalez, same thing when you switch sides. Thank you. Mr. Gonzalez, you may begin.
May it please the court. Thank you, Your Honors. Jason Gonzalez representing the appellant Coast Development Corporation, and 5 minutes for rebuttal is adequate for me. Thank you. As you know, Your Honors, we're asking this court to do two things in this case. One is to reverse the final summary judgment from the trial court because there are disputed genuine issues as to material facts. And I'll get into the misapplication of implied actual notice and duties to investigate that were used in that final summary judgment. I'm going to come back to that issue, spend the bulk of my time on that and answering your questions. The second thing we're asking the court to do that I'll just briefly mention is and it's very important, we're asking that you reverse the trial court's order that struck our amended expert report. And what happened there, and it's a reversible error what the court did because there was no finding as to prejudice, and the court didn't go through these Binger factors for a finding of prejudice. But what had happened there, we had a pending motion to continue the trial, a joint motion to continue the trial. And as happens in many cases during discovery and in our expert deposition, we learned of some things that led us to decide to drop one portion of our damages claim and address a different portion. The net effect of that was essentially zero with respect to our damages claim. But we submitted this amended expert report, and then Old Republic, the appellee, moved to strike that. The trial court struck it without any finding of prejudice. And then 2 months later, continued the trial, granted our joint motion. So there was another 9 months where Old Republic would have had plenty of time to address anything in that report. So that's reversible error. And that's really all I was going to say about that, and then get back to
Mr. Gonzalez, can I ask one question about that? Could you address whether or not that particular order falls within the scope of review for this appeal? Because it was not really related to the final judgment. It's not mentioned in the final judgment. It's really not a part of that. So it appears to be a non-final order that was preceding it. Can you just address whether or not that it was something that we can even address under the scope? And then secondly, whether this argument that they didn't make these findings was preserved?
Yes, Your Honor. I believe it was preserved. It was raised, of course, when the motion had been made to strike the report, and it was granted. And we think that it is part and parcel of the if this case goes back down for a trial, if we get our day in court, we think the issue has to be resolved so that we don't end up in this same situation and having to come back up on that. But the other issue with respect to our request that you reverse the final summary judgment, and I know you're familiar with the facts of the case from our briefs, so I'll just hit a few of the highlights. My client, Coast.
I'm going to ask, would you mind, I think we're pretty familiar with the facts. So it appeared that the trial court below had sort of this assumed exception and then a survey exception. Would you mind starting with the survey exception issues? Because I think this panel had some specific questions about that one. So I know it's probably out of order, but if you could focus on that, what the trial court made findings as to that and why you believe that was improper.
Sure, Your Honor. On the survey exception, and then it's not really that clear in the way Judge Gerard did the order. He just says that we had actual notice of a power line, and then just grants the judgment. He recognizes that Old Republic had been arguing implied notice, but he doesn't get into to really explaining how that was done. Now, you have a de novo standard here, so I don't want to get too bogged down in how he did that, but it was wrong because the survey exception. I mean, what governs both issues, both of these exclusion issues in this case, is the plain language of the exclusions. And the survey exception and exclusion in Schedule B, Section 3, it just says an encumbrance that would be disclosed by an inspection or an accurate and complete land survey. Well, the encumbrance we are complaining about from the beginning of this case is not merely a power line, and that's all that's in the. That's not all you have on the survey. You just have an identified power line. The same thing that we observed. But the encumbrance we're complaining about is a blanket easement, a very different creature. And I'd like to talk about the difference between a blanket easement.
Sorry, sorry to talk over you. I just wanted to make sure if we look at the language of what we've been calling the survey exception, I recognize that your client argues that it doesn't apply, but you're focusing on encumbrance. You're not focusing on any other language in there as it relates to, adverse circumstance, variation, violation, encroachment?
A power line, I think, could be some adverse circumstance. An encumbrance would be, we believe, the plain language is describing a legal encumbrance. We're not here asking the title. We wouldn't even be here if the issue was simply there's a single power line across the property, and that's an adverse circumstance, and we're calling on Old Republic to step in and move the power line. In some of these cases that they've cited, that's the kind of physical problem with the property that a claimant is trying to get fixed either by an adjoining property owner or a seller. What we're complaining about is a blanket easement, and it's very different than what I would describe as a traditional, conventional power line easement. And that would typically be just a strip of property defined by a survey. Usually they're 100 to 150 feet wide. That's a typical power line easement for a single power line. We're complaining about
if I'm looking in the record for the best depiction of the survey, the one that was best to me was 1268 at the record. We have everything scanned in, so it's not the most precise or clear, but is 1268 what we ought to be looking at for the survey, or is there a better one that's scanned the 3,000 page record?
Yes, the two that I've seen, and one was at 1268, one it's the one that's also the image of which is in the appellee's brief. That was the best image I saw in the record, and if it would be important to supplement the record so that you can see it more clearly, I think we could do that. But it was that is it, and you can make out the single power line across this property, but there's no mention of blankets.
Is that the one that's going from like 11 o'clock to 4 o'clock across the upper left-hand part of the survey, or is it something else?
I believe
I'm sorry for
it
the basic
is.
question. It's just not very clear to me.
Yeah, no, I understand, and it's important. I think it's highlighted in at 1268. I think it was in yellow highlighting, but I don't have it right in front of me. But I think after this, if it was important to supplement the record, we could probably get a higher resolution image of it. But I think we all agree, it doesn't say anything about a blanket easement encumbering the entire property where they can potentially move any power line. It's something you would never perceive as being an encumbrance, and it's certainly nothing to blame.
Would a survey ever show an encumbrance?
A survey would not do what a title search that Old Republic was supposed to do would show all the legal encumbrances. They botched the title search. We paid for a policy where they should have listed it in the exclusions on Schedule B, and they failed to do that. And the case law from this court, Norachi from 2010, this court said that on page 605, a prospective purchaser may rely on the title search, and the title company is obligated to answer for any defect. And, quote, this rule has been found to apply even where the insured is alleged to have actual knowledge of a material defect at the time of closing. We had no knowledge of this, and there would potentially be facts for a jury to determine with respect to what we did see. I don't think under McDaniel and these other cases, McDaniel says whatever we observed either on the survey or in inspection, McDaniel's saying it's got to be something so obvious that a reasonable person upon inspection of the premises would perceive the encumbrance being a blanket easement covering the whole property, a very unusual and restrictive legal creature that is not used very much anymore. Something 100 years ago was more common, but it encumbers every inch of this property. We had no knowledge of it. We paid them for coverage, and they botched their title search. And we have every right under Norachi to rely on the title policy in their botched search. And so they have to provide
Mr.
coverage.
Gonzalez, would it be fair to say that the issue that you believe is the material fact in dispute is not necessarily the idea that the buyers saw the power lines, perhaps should have assumed there was an easement, according to some of the case law like Morton and some of those others following McDaniel? Is it your argument that there would have been no way for them to understand the scope of the easement, and that's a material fact in dispute? While they may have seen the power line itself, may have thought, oh, the power company can come repair this, it's the scope of this blanket easement that's the issue.
Well, I don't know if I would even say it's the scope of the easement. It's an entirely different legal creature, a conventional easement where you have a very limited rights in a defined limited right-of-way strip versus a blanket easement where they can do pretty much anything they want anywhere on the property. So I really don't think it's just a matter of degree. It's a completely different legal creature. It was recorded in the records in 1973. There was no reason why if they had performed a competent title search that the statute says they're supposed to be able to do, then it should have been picked up. But what they're doing throughout Old Republic in their brief, they're pulling in this concept of implied actual notice. We saw a power line, and then they take a couple of steps.
Before we get to that, is there any scope of easements that could have been on that property, and think of it as narrow as you'd like, that would have brought the survey and inspection exception into play? Or did that never apply in your client's view?
Well, what we observed and what's on the survey that's subject to the plain language of this text that we would assume or agree to is just what we saw, and that was the power line. Now, there are fact questions. If you go, if the jury is weighing what we observed, it may be that a reasonable person under what the McDaniel case says may look at the factors depending on where the power line was. If it ran into a structure, they may perceive there's no public utility, publicly recorded easement that some third party has because it's running into a property. It may be that somebody would find it so obvious with one traversing the whole property, and maybe there's certain facts about the utility company's got its name on a pole or something that maybe it would be so obvious that somebody would perceive a traditional power line easement. No reasonable person would perceive a blanket easement over an entire 100-acre parcel because they saw one single power line running across the property. So I'm saying, at least in this case,
Mr. Gonzalez, doesn't the McDaniel court sort of contemplate this exact thing? I mean, in that case, there was one line that went along the edge of the property. So they said there's factual issues as to actual knowledge. But they said, since the existence of the power line would ordinarily be sufficient to put a person on notice to make inquiry as to whether the easement existed. If the line crossed in the middle of the subject property, the appellants cannot reasonably say they did not know or should not have known of the existence of the easement. It doesn't say how broad of an easement, just your client should have known of the existence of the easement because the line went right through the middle of the property.
Yes, Your
Isn't
Honor.
that case sort of distinguishable from the facts of our case?
And Your Honor, I would expect that you'll hear some about McDaniel from Old Republic Counsel. And this is, they argued extensively this Judge Del Wallace's circuit court, trial court decision up in Jacksonville. They argued it before the trial court. The trial court doesn't mention it, but the trial court there was following that single sentence in McDaniel that was dicta. It was a superfluous sentence. Of course, McDaniel ruled in our favor, essentially, that there was coverage. That's a sentence of dicta. No court, no appellate court, no DCA, Florida Supreme Court have ever, in the title insurance coverage context, had this concept of implied actual notice. Never once. And this would be a very good question for Old Republic's counsel. Can they name a single case where the holding of the case had charged a purchaser, a title insurance policyholder, with implied actual notice and a duty to investigate in a title insurance case? There's not, and I'll tell you the answer to the question. There's not a single one, including McDaniel. That's not the holding. And there's no other case that does that other than Del Wallace's circuit court summary judgment that was never appealed and was just wrongly decided. What they do, Old Republic, and this is one of those things where, as my wife would say, you read Old Republic's brief and they've got all these cases that mention implied actual notice. And my wife would say, we need some godly discernment here, because if you look at all those cases, not a single one of them using that phrase is a title insurance coverage case. And that's a unique relationship where the statute says we've got somebody in that relationship being paid to do a competent title search. And the buyer it holds the policy, is supposed to be able to rely on that. There's nothing in this policy language, these exclusions in the plain language, that accepts that. And all of these cases that they're citing are not title insurance cases. Fisher, Flanagan, Romex, Sapp, Zalcha, Simons, Tarin, Cotting, Dolgen Corp, Tri-County Produce. And so this is like the sleight of hand. They're trying to pull this concept out and ask this court to be the first one in the state of Florida to impose these duties on a purchaser, a holder of title insurance. That will completely, fundamentally change the relationship and the duties between a title insurer and the purchaser. You can no longer rely on the title search. I think any real estate attorney, if that was the holding, if this court is the first one to do that, any real estate attorney would commit malpractice if they don't advise their purchaser to go out and hire some professional to inspect every single physical feature on the property and do an investigation and a rundown. What are all the circumstances behind that? Is there an adjacent property owner that maybe is claiming some type of access easement? Is there a municipality that's got a maintenance easement through a creek bed? That has never been the law anywhere in Florida. And we have to be careful, because Del Wallace did this in the circuit court case that never went up to the first DCA. McDaniel doesn't do it. It's dicta by any definition. That's not part of the holding, and it shouldn't be part of the holding in this case.
Counsel,
And I
you are
see
into your
now
rebuttal.
I'm into my rebuttal, so I will reserve the rest of my time.
Thank you. All right, Ms. Hatchett, we're going to get started, and I'm just going to go ahead and ask a question before we start the clock even to get you going. If you could also kind of focus on the survey exception and that area starting out, I think it would be helpful. Thank you.
Absolutely. May it please the court, Your Honors, Maya Hatchett from Winder Riedel Haynes Ward Woodman on behalf of Old Republic National Title Insurance Company. To get specifically to your issue as to the exception for the survey, I think I have to start with the plain language of the policy itself, which Your Honor, Judge Trevor already brought up in regards to it. It is more expansive than what Coast is attempting to argue at this time. Specifically, Exception 3 of Schedule B excludes coverage for any loss or damage by reason of any encroachment, encumbrance, or adverse circumstance that would be disclosed by 1, an inspection of the property, or 2, a survey of the property. In these circumstances, the fact—
I'll ask you the same question, Ms. Hatchett, that I asked Mr. Gonzalez. Which of these is your client saying applies? Are we talking just about encumbrance? Are we talking about adverse circumstance? Are we talking about something else?
I believe it is encumbrance, Your Honor, and adverse circumstances based upon the controlling case law of McDaniel and lawyer's title.
What weight do we give those two cases, given the differing language in the analogous exception? In other words, McDaniel talks about facts. That's not contained in the policy at issue here. The other one, Morton, talks about other matters that aren't at issue here. Encumbrances and adverse circumstances are not mentioned in the plain language of either of those policies in Morton or McDaniel, correct?
In the McDaniel case, Your Honor, the survey exception that is applicable is the exact survey exception that is in our case. The facts are on all fours with McDaniel in regards to it still being a power line. I agree that the facts McDaniel's court had to deal with was that the power line traversed only the edge of the property, and that the court made a clear distinction between those circumstances and what we have here, where the line goes directly through the middle of the property. I don't know if it would be helpful, and I don't know if it's permissible with Your Honors. I do have a blow up of the survey that's literally next to me right now that I could hold up if that would be at all helpful to depict how clearly the lines run through the middle of the property. It cannot be disputed that the facts aren't disputed. One, the corporate rep of Coast admitted that the lines ran through the middle of the property. The surveyor of Coast that Coast obtained the survey from prior to purchase of the survey made it clear in his deposition that the survey clearly depicted, and it was obvious, the lines running through the property. And finally, in the summary judgment hearing, counsel for Coast admitted not only that Coast had expressed knowledge of the power lines, but that they should have done more and that they had the duty to do more and did not take the duty.
How would you address this sort of argument that this type of easement is more than even one might suspect with a typical power line? So perhaps you'd see a power line and you'd think, oh, they can maintain the power line. And maybe a reasonable person could think that. But how would you address this issue raised by Mr. Gonzalez, that it's the scope of this easement or the actual legal easement is just very different, meaning they have access to the whole property, and how would they have known that?
Yes, Your Honor. The scope of the easement first is an issue that has been raised for the first time by Coast on its appellate brief. It was not something that was raised on the lower level. But with that said, it still is not does not change the outcome of this case. Specifically, the controlling law is clear that it is unequivocal that an insured can be charged with implied actual notice of a condition. It is not required that it reveal all the non-physical rights and obligations of that condition. Specifically, although it is not controlling but can be persuasive, would be the first Coast case where that analysis was done and by the lower court, and showed that whatever rights the power company had, the insured was obligated to investigate. Similarly, the controlling case law of McDaniel and lawyer's title make it clear that what is at issue is the condition, and that upon implied actual notice of the condition, they had the duty to investigate. There is no case in Florida that differentiates the obligation to inquire or lessens that obligation due to what the nature of those rights are.
What does that duty to inquire look like?
I'm sorry.
What does that duty to inquire look like? Who should they inquire of?
Once they are put on notice of a condition, they have a duty to inquire. In this specific instance, because there are power lines, they had the duty to inquire to the power company what rights and obligations those lines had.
Assume for me for a second the facts are a little bit different and it's not power lines, that it's a fenced-in property, whether it's residential or commercial, it doesn't matter. And in the back corner of that fenced-in property, there's a small electrical box. Does your position change? Does the survey exception still not apply in that particular situation? Say the person goes onto the property and notices the box. What does the duty to inquire in that case look like?
I think that issue was addressed by the court in the case. And I'm blanking on the name that I cite to it in the appellate brief as to a stream, and simply that the county had mineral rights running out of the stream that ran through the insured's property. In that case, the court did an analysis that just because there is a stream in the property, it did not trigger the duty of the insured to inquire because it did not provide adequate notice or implied actual notice of the condition. The fact that there is a box on the back of the property, a box would probably be found in 9 out of 10 properties. And therefore, I think the argument would be made analogous to that situation, that a simple box on the property would not advise the insured of a condition to put them on required to do a further duty to inquire.
So we're talking about size, basically. So like, take the exact opposite example in the middle of a property, a giant cell phone tower. It would seem that there's a duty to inquire. Is it size that's the issue? Because in the case that you're talking about, I thought that it had to do with the fact that it wasn't observable at all. They were mineral rights.
Respectfully, Your Honor, I do not think it has to do with size. I think it has to do whether or not it is clear and physically observable as a condition. And in the circumstances of a stream, it does not reveal that there's a condition with that stream, similar to just having a box on the property to obtain it possibly could in that regard. I guess it depends on what issues at issue, but to the extent that it is simply that there is power running to the property, yes, there is. I guess it would show that there is power running to the property.
But I mean, couldn't that analogy hold? Because I mean, isn't that what the power lines show? Like there's power running through the property. In other words, I wonder if we see it your way, if we don't effectively invalidate every residential title insurance policy in the entire state, because it would seem that if I've got an electrical box in my fenced in backyard, I've got a duty to figure out whether that's cable or electrical, or whether it's some other utility commission. I've got to figure out whether it's active or passive. I don't know who I call.
I think that it comes down to whether or not the condition is physically observable on the property and that there is a duty to inquire. But I do think it starts with the exceptions because the title policy is a contract. It starts with the plain language of the contract. And in this case, with the exceptions, if there is a survey that reveals the utility box and clearly shows that on the survey, I do believe that the insured is charged with those rights in that regard to the extent conditions arise out of that.
But what does the duty to inquire look like in that instance? As a residential homeowner, do I have the obligation to just start calling around power companies and ask, is this yours?
I think that it based upon, yes, I think that you have the duty in our particular circumstances. We were dealing with a developer of residential property that the president was an attorney, that the second in command was very knowledgeable about the industry. So in our circumstances, the facts are very clear that they had the knowledge to be able to investigate and to look up the who controlled the utility. In normal circumstances, it is not unreasonable to obtain what utility company services an area.
But if we were to draft this opinion, I think is what, as Judge Traver has said, that said, if you can observe a condition, there's some kind of duty. Are we going to now distinguish between a sophisticated purchaser and an unsophisticated purchaser? And then leading even more so, wouldn't all of this to some extent go to a question of fact, material fact? In this case, should these developers have realized it or not? Would that not be perhaps a question of fact? So there's a two-part question there. But in drafting an opinion, what would that look like to where we said, you have a duty, but it only applies to people who should have known because they buy property all the time? I'm just confused about how that would play out in an opinion.
I think that the McDaniel case makes it clear that there is a difference between a power line running down the side of the property and running through the middle of the property, as we have here in this case. Therefore, if it is that there is no dispute, and I think what it comes back to is, in this case, there is no dispute as to why it is proper for summary judgment, that it is admitted that the line ran through the entire middle of the property. And it also is admitted as to the issue of whether they should have known. This is not an issue of whether they should have known. They did know.
What if it was one power pole in the middle of the property? Still the duty to inquire? So a
Yes,
pole, no line.
I guess it would be dependent upon the facts, but if there is a power pole that powers, in this case, these lines are up in the air, the lines are running through them, and it traverses through the middle of the property. Not only did the plaintiffs, their president and their property project manager go out to the property 15 times prior to purchasing the property, but they obtained the survey that shows these exact lines, which are connected, running through the middle of the property.
Same question I asked Mr. Gonzalez. Would a survey ever show an encumbrance?
I'm sorry?
Would a survey ever show an encumbrance?
It will not detail the scope of the encumbrance as to whether it is a blanket or a prescriptive, but I believe it will show the physical encumbrance.
It would show the facts. Well, are we talking about encumbrance like a big boulder on the property, or are we talking about encumbrance in the way that it's defined, say in like Black's Law Dictionary, that refers to it more like a cloud on title? And I know that that's not precise. I can read the Black's definition if you'd like, but then I'd have to click over to another screen.
I believe that it is that is defined by what is that is determined by the surveyor and in accordance with the regulations for survey. I don't believe that a boulder will actually be placed on a survey, whereas power lines and other encumbrances are found on surveys.
Well, I mean, oak trees are placed on surveys, right? So I'm just wondering, my question is, if it's a legal terminology, an encumbrance is something like a mortgage or a lien or an easement. I mean, one of the reasons I was asking about the record site for the survey is I can't tell that it specifically says encumbrance on there or it references an easement. It shows the facts that might give rise to an easement, I think, which is what McDaniel talks about. But does it show an encumbrance, and could a survey show an encumbrance from a legal standpoint?
I believe that the survey shows that there is a condition that I think it does. The survey does not define an encumbrance. So I think that it has to go off of case law as to what is shown and what is seen as an exclusion to coverage under the survey exception.
So then it'd be an adverse circumstance?
Does it show an adverse circumstances?
Yeah, so if it's not an encumbrance, if we look at the plain language of your client's policy, and if it's not an encumbrance and if it's not a violation or any of the other things that talk about there, then it has to be an adverse circumstance, right?
I think that the cases that address, there are cases that address, the cases do address that when it is not a physical condition, that is not something that the parties can be charged with. The Supreme Court has made it very clear that the duty to inquire and the charge of implied actual notice is vested in physical observable traits on the property. And in circumstances where that is not the case, then the implied actual notice cannot be found and the exclusion does not apply. That is not what we have here. If I may, please, the court, I would like to just briefly address the issue of striking of the motion or the renewal of the striking of further expert testimony, if I may. I do think it is moot because I do believe that the trial court properly found, and I do believe that the facts and the law support summary judgment for basing the summary judgment in favor of Old Republic based upon the plain language of the policy. But with that said, the court did not err in striking Coast experts' opinions not previously given in deposition. Although Coast is attempting to argue that somehow the courts struck the expert's opinion across the board, that's not the case. They have expert opinion, but based upon their conduct in this case, and I respectfully, I know that counsel tried to depict it as simply finding out facts. That's simply not what occurred. And I think it's outlined very clearly, not only in the lower record, but also in my appellate brief. This is a circumstance where fabrications were done in discovery, where we took up more than 10 depositions. And it was only through going through all these depositions that it actually came out some of these fabrications. Specifically, the 50-foot buffer easement that was the premise of the Coast case was found out through the testimony of a city employee, corporate representative, that it was not something that was incurred as a result of the easement or having to move the easement, but rather was something Coast voluntarily agreed to. The issues that caused the court and to strike further expert testimony of Coast specifically deal with facts Coast had knowledge of when they originally made them. With that said, I would just come back to the issue of the summary judgment and why it is proper. It is undisputed in this case that there was actual notice of these lines. And because there was actual notice, they had the duty to inquire. And based upon the controlling case law, McDaniel, Lawyer's Title, Kraus, and Narachi, the recovery or coverage under the title policy was barred.
Thank you,
Where
counsel.
in McDaniel does it say that the language of the survey exception is exactly the same as it is in this case? Again, I apologize for the basic question, but I'm not seeing it. Doesn't mean it's not there. Because it looks to me like
the title policy, like the title policy at issue in our case, stated it excluded facts that an accurate survey or personal inspection of the property disclosed would have disclosed.
Are you viewing then no distinction between you're reading facts synonymously with encumbrance and adverse circumstance?
I don't believe there's any distinction, Your Honor, and based upon the court's opinion in McDaniel, they are one and the same.
Okay.
Any more questions? Harris? No. All right. Thank you, counsel.
Thank you, Your Honors.
Mr.
Thank you, Your-
Gonzalez?
Yeah, Your Honor, just to respond to one of the last things we heard there about the duty to inquire further, and this goes to questions that Judge Traver and Grosshans had asked. Page 18, right at the top of page 18 of the appellee's answer brief, they say knowledge of the power lines created a duty to inquire further, period, no citation. There's no citation in their brief when they say this, and they said it again today, with no authority for it in a title insurance coverage case, because that has never been applied. And I have to correct, she said that the Florida Supreme Court, when it imposes the duty to inquire and the implied actual notice, the Florida Supreme Court has never imposed that in a coverage case in title insurance in that relationship, where all the statute in all these cases have said that the purchaser and the holder of the title insurance policy can rely on the competent title search of the title insurer. That's what we're paying for. Why else would we be paying for that if that duty goes on us? And going back to what Judge Traver was asking Old Republic Counsel about the survey exception language, and counsel said that it could be the encroachment or the adverse circumstance, but it has to be disclosed in the survey. And a blanket easement is never disclosed. Even if we had a better image of that survey, I'm certain there's nothing about a blanket easement disclosed there. If you disagree with me that because there's a because there is a single power line identified on that, maybe that is enough to somehow perceive a blanket easement. If you disagree with that, that's a good question for a jury then to go look at the circumstances, let them look at a high resolution image of that survey and say, is that something that would indicate would a reasonable person look at that and think there's an easement covering every inch of this property, that a utility company can move lines, add lines, maybe other type of lines, the gas line, and they don't have to give notice to the owner and they can run them in any direction? I don't think a jury is going to find that way, but that's a question for the trier of fact. And that's why there are disputed, genuine issues as to material fact, and you should reverse for that reason, even if there was some of these duties that have never before been applied to the purchasers. Thank you, Your Honors.
All right, thank you.